You're in a faraway place and you want an act done. You're in a faraway place, you want your property to be sold. You're in a faraway place and you want somebody to represent you in a business transaction or even going to court. You don't know how to do it. You don't know what to do. What is the lawful way for you to do that? There is what is called power of attorney. This is what we'll be discussing today. Power of attorney. Click on the subscribe button, like this video, share with your friends and fans, and drop your comment in the comment section. Let's go into deep more into what is a power of attorney, who can give a power of attorney, and who can be assigned as a person to conduct or to carry on the affairs that is stated in the power of attorney. Thank you. Hello everyone, my name is AI Ango. I'm a legal practitioner, a notary public, and a chartered arbitrator. Today we'll be discussing power of attorney. Some people mistakenly call it power of attorney.
Oh my God!
It is not power of attorney, but it is power of attorney. What is a power of attorney? Power of attorney is a legal document donated by a person to another to carry out a specific duty on behalf of the person. The person donating the power of attorney is called a donor, while the person who the power is donated to is called a donee. So a power of attorney is an authorization from a donor to a donee to carry out a specific act that is being captured in the power of attorney. For example, where Mr. A is unable, due to one reason or the other, to carry out a specific duty or to sign a specific document, he can, by a power of attorney, now assign Mr. B to carry out that duty he is supposed to carry. Meaning, it will be deemed as if it is Mr. A that has done this job by himself. Let's look at it in a very more simple example. If Mr. A wants to sell his own house, and Mr. A probably he's in abroad or he's somewhere else, and there's need for Mr. A to sign the deed of assignment, the sales agreement, Mr. A cannot be gotten or is far away. Mr. A can say in a power of attorney, he can give a power of attorney to Mr. B that Mr. B should sign on his behalf on this specific transaction. And if Mr. B signs, that is as good as it is Mr. A that signs. Even before the law, it is recognized. Power of attorney can be given in any kind of legal, lawful act. You can assign somebody to carry any lawful act. For example, the sale of a house that we said, or the taking care of your property. A landlord can assign a caretaker with a power of attorney to collect rent, to take charge of his property, to eject or give out rent to tenants, and any other act the landlord feel the caretaker can do. Now, it is with that power of attorney that the caretaker can do so. Also, a client can give a lawyer a power of attorney to appear in court on his behalf or to do any other act that is lawful on his behalf. Now, a power of attorney is the power that gives the representative to do an act as if he is the owner. We must take note that simply because a power of attorney is given to a person, that does not confer ownership of that property to that person, or that does not confer authority, complete authority of ownership on that person. It is just for a specific duty. Now, a power of attorney must contain the name of the donor, that is the person giving the power, and the name of the donee, the person who is given the power to carry out a specific task. Also, the power of attorney must also carry the specific task that the donor wants the donee to carry. The duty or the act that the donee must do should be specifically slated or spelled out in the power of attorney. That is what will give the donee the power now to do. The donee cannot do anything outside what has been stated in the power of attorney. If he does that, he is acting, in law we say, ultra vires, which is he's acting out of the law. So, the power of attorney must contain the duties or the act the donor wants the donee to do. And if the donee executes that task, then that is completely done. It is deemed to be as the owner of the property, or the donor is the one that has done that. So tomorrow, he can't come to say he didn't appoint or he didn't ask the donee to do so once there's that power of attorney. And also, if you are transacting a business, if you're doing any act with anybody that is saying he's doing it on behalf of another person, the first thing you should ask is, can I see the power of attorney authorizing you to stand on behalf of the main owner? If there is no power of attorney, my brother, my sister, don't get involved in that act. Be sure you do it with the owner of the property or owner of the business. Don't just say, okay, believe that the man told me to come on his behalf, and then I should sign on his behalf, and then whatever we do is as good as if he's the one that has done it. Don't agree. Ask for the power of attorney. See the power of attorney. Get your lawyer to go through it to verify if it is genuine or not. Now, once you see the power of attorney, you are as good as gold. Go on with the business. Now, for a power of attorney to be recognized by law, once a power of attorney is donated, it must be registered. You should check that. It must be registered. There must be a notary public that has endorsed the power of attorney. After it has been executed by the donor and the donee, there must be a notary public that should stamp it and seal it, or it should be taken to the court before a commissioner of oath to stamp it. Then that power of attorney carries the backing and the power of law. But any power of attorney that is just plain like that, without a seal and stamp of a notary public or the commissioner of oath of a court, then definitely that power of attorney is incomplete. It cannot be tendered in court. It cannot be used in court. It is as good as just a paperwork. So you must be very careful when somebody tenders a power of attorney to you and says, this is a power of attorney giving me the power to stand on behalf of the owner of the property. You must make sure you check to see if it has been signed and sealed by either a notary public or a commissioner of oath of the court. Now, a notary public is a person assigned by the Supreme Court to sign and seal documents that can be enforceable in court. So that is a power given to legal practitioners. Just like I am one, I can sign and seal the power of attorney and any other document that can be used in court. So do any other notary public. So if a power of attorney is carrying that, and then the specific assignments assigned to the donee is slated therein, is good. Then you can go into that business, or you can sign the document, or the donee can sign on behalf of the donor, and that transaction is as good as done. We must understand that a power of attorney is irrevocable. Once you grant a power of attorney, it only expires after the execution of that task that is contained therein. For example, if a power of attorney says that the donee is to act on behalf of the donor in the sale and signing of any document that has to do with the sale of a specific property in so address, and he is to collect all the money that are to be given in respect of the sale and kept in his own account. You see, these are duties that are being spelled out for the donee. Then if you see that, now the power of attorney will remain in force until that property is sold, the donee signs the document on behalf of the donor, and then the money is paid to the donee, and he also kept the money in the account stated. That is only when that the power of attorney now would cease to be in force. But the power of attorney cannot cease to be in force or cannot expire simply because the donor is dead, or the donor has gone bankrupt, or the donor has gone insane. The power of attorney cannot expire. It will continue until the task in it has been executed. So simply because a donor of a power of attorney passes on, his relatives or children cannot come to say, no, you the donee should hand over whatever assignment has been given to you. It will not work. As far as the law is concerned, and as far as that power of attorney is registered, signed and sealed by a power by a notary public or the commissioner of oaths, that task can only must be executed by the donee, and that is when it will expire. So we must take note that once that is done, that is just all. Or some will say once a certain amount of money is paid, then the power of attorney is expired or has expired. So once that payment is done, definitely it will expire. But as long as it has not been done, the power of attorney still continues. So, by way of conclusion, we will say a power of attorney is an authorization by somebody to another person to carry out a legal duty, a lawful act. Understand that any illegality, a power of attorney cannot confer that power. So if it is not a legal act, if it is not a lawful act, that is not recognized by law. So it must be a lawful act. A lawful act which the law recognizes, and that is what you can enforce in court. For example, if it is an illegal act, when somebody will give you a power of attorney to go and commit a crime on his behalf, that will not stand. It will not stand. So it must be a lawful act, and it covers all space of human activities, all space of human lawful activities. So understand this and then walk by the law. Don't just get into a business with a third party without a power of attorney. This is a very candid and sincere advice. Ensure, no matter how trustful that person appears to you, ask for the power of attorney. The highest trust is when you see the power of attorney duly executed, stamped and sealed. Then you can get involved in that business. Don't get mad. Just get a lawyer. Thank you for watching. Please subscribe to this channel by clicking on the subscribe button, like, comment, and share with your friends. Thank you.